Can an employer put a provision in a contract that requires the employee to be actively employed in order to get their commissions or bonus or incentive payments or variable compensation or whatever you want to call it? Is a complicated and interesting question. Hello everybody, my name is Grant Engrav. I'm a partner at Engrav Law Office. We're very excited to have recently litigated a complex case that changed the law in regard to this question, and I'm going to share a little bit about it, what we learned, and some issues that are still outstanding today. And briefly, before we get into this video is meant to start a conversation on LinkedIn, so please let us know your thoughts. But know that this is not legal advice. This is just educational information on some recent legal updates. Okay, so can an employer in a contract require the employee be actively employed? This is directly the issue that we dealt with in the employee's contract in the Larsson case. It said that he must actively be employed 90 days after the close of the quarter. And the particular challenge for the employer in this case is, if you think about it, a quarter is 90 days. So we have to break this down in order for it to make sense. But if an employee with DXC worked from January 1 through the end of quarter 1, right, through March, they would not get their incentive payments for quarter 1 unless they worked 90 days after the close of Q1, meaning they're now at the end of Q2. But here's the problem. You've now worked all the way through Q2, presumably making sales throughout that entire period, and now you have to work through the end of Q3 to get your Q2 payments. So we used an analogy of the myth of Sisyphus, or the one that I liked even more, but we didn't include in our brief, was that cartoon where the dog's holding a stick with a carrot and is always chasing the carrot. And that was the issue, right? You can see how that might plug into fairness, particularly when the employer receives the revenue from the sale that's being made. So the issue in this case was, is the payment at issue a commission or is it a bonus? And Oregon law has a lot written on this subject. There's at least 3 key cases to talk about. There's Walker, Thompson, and Martin versus DHL. I'm going to really just limit today's conversation to Martin versus DHL. It was the controlling case from the Ninth Circuit when they made their decision. When you read Martin versus DHL, it is directly on point, but in my opinion, there was some unfortunate wording from the court as they used a 3-prong test, and the first of that prong asked whether or not the transaction was keyed to the payment. So this term keyed is what I take a little bit of issue with. But what the court is getting at is, if we could use an analogy for a car salesperson, what unlocks the pay? Is it the individual sale and the employee gets 10% of each sale? Or does the contract say that the employee is going to get 10% of their salary, for example, if they hit a certain goal or quota or target, are terms that you'll often hear in these situations. So in Mr. Larsson's case, it was critical to the case that we argued that there was no quota, which the Ninth Circuit agreed with, and that his transactions were keyed directly to his compensation. So the battleground there was, do we look at some aggregating of his sales, and then what is the numerator, what is the denominator that decides his pay? Or is it just like any other situation where if he makes one sale more, he's going to get a percentage or a proportional amount of that sale? And that is the key of the 3 factors in Martin versus DHL. The other 2 factors in that case are whether or not the compensation was regular and whether or not it was for something above and beyond, right? So the court didn't opine on what it meant by regular. That could either be frequency, or it could be the amount of his total compensation or an employee's total compensation. Right? So is the commission or incentive payment at issue 20% of the employee's total compensation? Is it less than 0.5%? And does the employee get paid on that payment weekly? That would certainly be regular in my book. Quarterly is kind of in the middle. Annually, I think it's clear from the court's analysis, weighs more towards a bonus. A bonus, right, is going to be discretionary. And it appears under Oregon law that if compensation is truly a bonus, the employer can make it contingent or conditional that the employee be actively employed. So if the contract, for example, says that the employee must actively be employed on January 1, and we're dealing with a bonus, and the employee is fired in good faith, or resigns in December, then that employee most likely is not going to get their outstanding compensation or the compensation that they thought they were going to get. But here's where Martin becomes so important. If that compensation is deemed a commission and the employee has done what they need to do to make the sale, and all that's waiting is the payment, as there often is a lag, right? We're waiting for customers to collect. We might be waiting for the accounting department with the company to make the determination as to how much the employee is going to get from the transaction. Then we are then the employee is going to get paid that compensation, even if the contract says that they must actively be employed. So it's a complicated area of law. Probably am going to make a couple videos on this. If there are additional questions or points that people want to make, I'd be happy to address those in future videos. Thank you.